Good day, and welcome to week 1 of Managing Dismissals and Unfair Labor Practices. During this week, we will be assessing unfair labor practices and the elements of it in order to understand what would lead to an unfair labor dispute stemming from such practices or treatment. Significant court precedents will be considered together with codes and practices that must be complied with to prevent procedural and substantive irregularities. We will further consider the different types of dismissals and the provisions of Section 186 of the Labor Relations Act as amended to understand the requirements for procedural and substantive fairness. Therefore, in this week, we will be assessing the definition of unfair labor practice. We will analyze the regulatory framework relating to resolution of disputes for unfair labor practice. We will discuss procedural and substantive fairness, and we will apply the requirements for procedural irregularities to practical situations stemming from a recent court judgment. At the end of the week, you will be able to watch a video which will contain a summary of the work we have covered this week. Introduction. During this week, you have read the required readings and case law, in which you firstly analyze the meaning of unfair labor practice. In addition, you have looked at the regulatory framework and the interpretation of same by the Labor Court, the High Court, the Labor Appeal Court, and the Constitutional Court, taking note of the principles that emanate therefrom. In doing so, you would understand the obligations of the employer in this regard. Further, you would have noted the difference between procedural and substantive fairness in analyzing unfair practices and understand the requirements for procedural irregularities in order to apply them to practical situations stemming from court judgments and other dispute examples. Understanding unfair labor practices. Section 186(2) of the Labor Relations Act defines unfair labor practice as any unfair act or omission that arises between an employer and an employee involving the following: unfair conduct by the employer relating to the promotion, demotion, probation, excluding dismissals of probationers, or training of an employee, or relating to the provision of benefits to an employee. The unfair suspension of an employee or any other unfair disciplinary action short of dismissal in respect of an employee, a failure or refusal by an employer to reinstate or reemploy a former employee in terms of any agreement, and an occupational detriment other than dismissal in contravention of the Protected Disclosures Act 2000 on account of the employee having made a protected disclosure defined in that Act. To succeed in an action based on an alleged unfair labor practice, employees must prove that the conduct or practice complained of falls within the terms of one of the practices expressly listed in the definition above. What you would have noted from the case law and the readings is that the courts and arbitrators alike have differing views on what constitutes unfairness, and further, if unfairness is found, what the appropriate remedy would be in order to put the employee back in the position he or she would have been in had the unfair labor practice not occurred. Legislative framework, understanding the law. The right to fair labor practices is enshrined in Section 23 of the Constitution. Section 23(1) provides as follows: everyone has the right to fair labor practices. The Labor Relations Act 66 of 1995, as amended, was promulgated pursuant to Section 23 of the Constitution to provide detail to Section 23. Section 33 of the Constitution provides for just administrative action. Therefore, the Promotion of Administrative Justice Act of 2000 will apply in instances where the employment relationship is not governed by the LRA. In other words, those who are expressly excluded from the ambit of the LRA. A list of other significant legislation governing the employer-employee relationship would contain the following: Basic Conditions of Employment Act, Compensation for Occupational Injuries Act, Employment Equity Act, the Unemployment Insurance Fund, Occupational Health and Safety Act, South African Qualifications Authority, Skills Development Act, the Skills Development Levies Act, and, of course, South Africa's obligations in terms of the International Labour Organization. For purposes of dispute resolution, various processes and forums can be used to ensure an efficient and cost-saving manner for the resolution of disputes. The process followed will be informed by the reason for the dispute and the provisions of the employment contract in this regard. Resolution processes will be, if internal, based on the disciplinary policy and procedure, mediation, or any other agreed alternative dispute resolution process. If external, it would be bargaining councils, the CCMA, the Labour Court or the High Court, the Labour Appeal Court, and the Constitutional Court. Procedural and substantive fairness. Procedural fairness is a process which gives the employer and employee an equal opportunity to present their versions about a work-related issue to a neutral chairperson to decide whether disciplinary action is justified. It is important to identify whether or not there is a workplace disciplinary procedure that applies. If there is no workplace procedure, Item 4 of the Code of Good Practice of the LRA must be followed. If there is a workplace disciplinary procedure, its legal status will affect the approach taken when assessing procedural fairness. Substantive fairness is the termination of employment without good cause or justifiable reason. Substance refers to the merits of the reason for dismissal, and this must be based on sufficient evidence to prove that there is good reason to dismiss an employee. The standard used to assess the measurement of evidence is referred to as the balance of probabilities. In other words, the employer's evidence must carry more weight than the employee's evidence. The scale is therefore tipped against the employer's in that its case should be more believable than the employee's version. Unfair dismissals, procedural fairness. This is a flow diagram that highlights the steps to be taken to ensure compliance with procedural fairness. The inquiry should be informal, and both employer and employee must be given a fair opportunity to state their cases and to question each other's cases. Compliance with the Audi Altrum Partem principle is pertinent. The inquiry will be conducted in accordance with the employer's disciplinary policy and procedures read with the guidelines in the LRA Code of Good Practice. Legal representation is not a right in internal disciplinary inquiries. However, it may be allowed should the parties agree. See the checklist for consideration in the flow diagram above. The rules of evidence in as far as presentation of documentary and witness evidence must be acknowledged. Unfair dismissals, procedural fairness. McGregor versus Public Health and Social Development Sectoral Bargaining Council and others. This Constitutional Court judgment is an important reminder that employees must be granted a fair opportunity to ventilate their case at a disciplinary hearing. Employers are generally required to grant employees an opportunity to be heard prior to dismissing them. It is only in exceptional circumstances, if the employer cannot reasonably be expected to comply with pre-dismissal procedures, that an employer may dispense with these procedures. In this case, the applicant, Dr. McGregor, was employed by the Department of Health, charged with misconduct for sexual harassment, and was dismissed following an internal disciplinary inquiry. He lodged an internal appeal against his dismissal, which was dismissed. He referred to an unfair dismissal dispute to the Public Health and Social Development Sexual Bargaining Council and challenged both the substantive and procedural fairness of the dismissal. The arbitrator found Dr. McGregor guilty of 3 of the 4 charges of sexual misconduct. However, he concluded that the dismissal was substantively unfair because of inconsistent treatment and procedurally unfair because Dr. McGregor was denied the opportunity to present relevant evidence, such as photographs, during the disciplinary hearing. The arbitrator decided that reinstatement was not appropriate in the circumstances of this case and awarded Dr. McGregor compensation equivalent to 6 months of his remuneration. In determining the compensation, the arbitrator took into account that he had found the dismissal to be both procedurally and substantively unfair. The Labour Court reviewed and set aside the arbitrator's findings on substantive fairness and found that the dismissal had been substantively fair. However, it agreed with the arbitrator that the dismissal had been procedurally unfair. Despite reviewing and setting aside the arbitrator's finding on substantive fairness, the Labour Court did not reduce the compensation awarded by the arbitrator, despite the fact that the dismissal had only been found to be procedurally unfair. The Labour Appeal Court agreed with the Labour Court that the dismissal had been substantively fair, but procedurally unfair. However, the Labour Appeal Court inadvertently failed to consider the issue of the compensation that had been awarded to Dr. McGregor. Unfair dismissals, procedural fairness, the McGregor case continued. The Constitutional Court refused Dr. McGregor's application for leave to appeal. However, it did give leave to appeal on the issue of what compensation should have been awarded to Dr. McGregor in the light of the fact that his dismissal had only been found to be procedurally unfair. The Constitutional Court held that procedural unfairness in a dismissal is significant and invites compensation to ensure that dismissals take place with the sensitivity and care properly required when the fate of people's livelihoods are at stake. The court further held that an award of compensation aims to give meaning to the right not to be unfairly dismissed, to discourage a shotgun approach to dismissals, and to recognize the right of an employee to be heard before action is taken against them. It is an acknowledgement of an employee's worth as a person. The court considered the possibility of not awarding Dr. McGregor any compensation at all due to the seriousness of his misconduct, but it took into account that all employees are entitled to fairness of procedure despite the seriousness of their misconduct. Instead, it decided to reduce the compensation award from 6 months to 2 months on the basis that 6 months compensation for minor procedural hiccups in respect of gross misconduct is entirely too generous and exorbitantly high. Conclusion. This week's learning outcomes is intended to form a valuable foundation for the weeks ahead. Stay motivated to read further in addition to your case law and article list. Now it's time to apply this week's information to practical scenarios. This will assist you with drafting your short summary or narrative, drafting a mini discussion paper on the legislative framework, creating a mind map, and creating a PowerPoint presentation. In the coming week, we will be analyzing problem-based scenarios of unfair dismissals.